Larry Lala here with another video case brief, Marbury versus Madison. Quick overview of what I'm going to do here. We're going to start with the rule itself, or what the case is about, how you can use it on an exam, and then we'll hop into, and this will be the bulk of the case brief, the facts and the kind of procedural background so that you can talk about it semi-intelligently in class. What is Marbury about? Two things in short. First, it's a reaffirmation of constitutional supremacy, that the U.S. Constitution is paramount, which is to say that if a law is passed by Congress and conflicts with the Constitution, that congressional law may be invalidated. In essence, it's a form of super law. Secondly, Marbury is about judicial review. The Supreme Court, as the third branch of government, and by extension the lesser courts that feed to the Supreme Court, are empowered to resolve conflicts between the Constitution and the laws of Congress. I use the passive voice here, but really what happened is that the Supreme Court empowered itself. A couple other notes here. Now, what I'm going to give you is a very simple overview of Marbury. A ton of ink has been spilled on this. This is just a super simple primer. How do you use Marbury? Well, it's almost useless for fact patterns. You're not going to find a case where you have to cite Marbury to figure out a normal issue spotting fact pattern in con law. In fact, Marbury's so foundational that it's kind of impossible to imagine doing a con law fact pattern unless judicial review is a thing. The way that you actually use it on an exam is that it's fodder for policy questions. So one key thing is to take very careful notes on your professor's thoughts on judicial review. Con law is one of the courses where you end up with a little less Socratic method and a little more professors lecturing. The professors who teach con law often specifically write about con law, which is a little bit different compared to other 1L subjects like torts or property. Very often those are not things that the professor writes about, even if they may be vaguely related to the specific matters that are of interest to the professor. So take careful notes on your professor's thoughts on judicial review. Something that I haven't written here, go look up your professor's law review articles about con law and about judicial review. Also, since this is a policy question, it's one of the ones where you might begin to pre-prepare an answer, or at least think about scenarios where the professor may ask about Marbury versus Madison. This is a common policy question. What would happen if we got rid of judicial review? Or why do we have judicial review? Could it look different? One thing to understand is what preceded the idea of judicial review. So the background is the former mother country, the United Kingdom. This is different now, but what existed at the time was parliamentary supremacy. Under such a system, the role of the courts is basically to decide cases and apply the law as it was passed by Parliament and not to question it. So we have a judge here. He goes, "Thy will be done, Parliament." And then we have Parliament right here. Thy will be done, Parliament. So the courts exist basically to interpret the laws and to apply them, not to question them. Let me give a little more context. We now have a constitution. We're about to head into a very contested presidential election. His rotundity, President John Masshole Adams from Massachusetts, and he's running against Thomas LLTJ Jefferson of the Democrat Republicans. This political context is important for Marbury because what Chief Judge Marshall ends up doing is threading a needle between two powerful constituencies. So let's represent that Adams is a masshole, and TJ is a Virginian. Now, again, this was a very bitter fight. The events that take place involve Adams knowing that Jefferson is going to take power. So the election took place in November, and the actual changeover doesn't take place until March. So Adams has all sorts of time to get in a bunch of new judges before the March deadline, including our friend Marbury here, represented by Big Papi. So, Adam's like, "You all are wicked smart." I'm sure he didn't talk like that. "Yay, we're all going to become judges." So, funny thing. Under Adams, John Marshall is appointed Chief Justice, but hasn't taken that role yet. He's now acting Secretary of State. For these judges to actually take up their offices, not only do they have to be appointed and approved by the Senate, they actually had to receive commissions. So Adams tells Marshall, "Send the wicked commissions." And Marshall's not even from Boston. It's like, okay. He sent most of the commissions. "Here are your commissions." God, I don't even know what accent that is. And they're all, "Here are their commissions." And they're like, hooray, we're going to become judges. But not all of the commissions made it out. Big Papi Marbury did not get his commissions. And he's like, dude, where's my commissions? And Marshall says, oops. So Marbury did not receive his commission to become a justice of the peace of the District of Columbia before Jefferson takes power. So March 3rd, he doesn't get the commission. March 4th, our famous Virginian becomes president. James Madison becomes Secretary of State. And Marshall takes his job as Chief Justice of the Supreme Court of the United States. Now, Marbury is still waiting for his commission. Being a bit naive, he says, hey, Madison, issue the commission. Madison declines. What commission? And this is what leads to the case of Marbury versus Madison. So the case is about Marbury's request for a writ of mandamus. It's making the court make an official do something. So Marbury's not the only plaintiff in this case. There's some other people who didn't get their commissions. He petitions the Supreme Court itself, including Marshall, now again the sitting Chief Justice, for a writ of mandamus to make Madison issue the commission. This is apparently authorized by Congress under Section 13 of the Judiciary Act of 1789. So here's a picture of the case. Marbury is like, dude, make him issue the commission that you forgot to send. Madison's response is, you can't make me issue that commission. Coming back, this is the context. Marbury is between a rock and a hard place politically. He was somewhat allied with the Federalists, which is how he became Chief Justice in the first place. So he's at least theoretically sympathetic to Big Papi Marbury over here. But this is the first turn of the political tide. Madison here, he's a proxy for Big TJ. There's also the justice aspect of the case, which is that Marbury did kind of get screwed. It's not his fault that the commission didn't get issued. This technicality didn't get resolved in time for him to actually become a judge. So Marshall, for unanimous court, answers 3 different legal questions. First, did Marbury have a legal right to his commission? The answer is yes. Second, does Marbury have a legal remedy? The answer is also yes. An injury has to have a remedy. Narrower question, is a writ of mandamus from the Supreme Court the right remedy? And Marshall's answer is not exactly. This question gets split into 2 other ones. First, is a writ of mandamus the right remedy? Yes, that would be the correct remedy. Now, can the Supreme Court issue that writ? And Marshall's answer is an emphatic no. So why can't the Supreme Court issue that writ of mandamus? The Judiciary Act of 1789 gave the Supreme Court original jurisdiction. Marshall's reasoning is that the Judiciary Act gave the Supreme Court original jurisdiction to hear writs of mandamus, but that Article 3 of the Constitution does not give the Supreme's original jurisdiction to do that. Now, Article 3 of the Constitution says that the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction. Madison or his attorney argued that Article 3 is a floor, not a ceiling on the original jurisdiction of the Supreme Court, and that the Judiciary Act just built on top of that. So Madison argues that there's basically no conflict between the Judiciary Act and Article 3. Marshall couldn't have disagreed more. According to Marshall, Congress can't be in the business of expanding or contracting the powers of the Supreme Court in a way that doesn't follow the Constitution. If Congress remains at liberty to give this court appellate jurisdiction where the Constitution is declared the jurisdiction shall be original, and original where the Constitution is declared to be appellate, the distribution of jurisdiction made in the Constitution is in form without substance. In other words, there should be no modification that Congress can make to the Constitution's grant of authority to the Supreme Court. Marshall then says the next question is how to resolve this conflict. The question that Marshall establishes basically answers itself. Oh, and by the way, the Supreme Court is the one that shall decide if there is a conflict and how to resolve it. And this is the most famous language, the most quoted language from Marbury, and part of me doesn't know why. It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If 2 laws conflict with each other, the courts must decide on the operation of each. I feel like this is the important part, and this is a general epigrammatic but not entirely helpful sentence. But it's super famous, and you got to know it. Oh, one other thing Marshall throws in. By the way, the Supreme Court can strike down a law of Congress if it conflicts with the Constitution. No big deal here. According to Marshall, thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle. supposed to be essential to all written constitutions that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. So, a couple paragraphs. The Supreme Court must say what the law is, must interpret both a law of Congress and the meaning of the Constitution, so there's wiggle room to bend both. And if there's a conflict, the Supreme Court can strike down a law passed by Congress, a co-equal branch of government under the Constitution. So here's the kind of Animal House ending to all this. Marshall goes on to be Chief Justice for another 30 years, maybe the most famous Chief Justice of them all. Marbury never got to be a judge and probably hated Marshall the rest of his life. This is a funny case because Jefferson got what he wanted. The Adams lingering judges were not given commissions and did not take office. But he complained of what he considered, probably rightly, Marshall's power grab. Jefferson goes on to talk about how blah, blah, blah judges are dangerous and shouldn't be the ultimate arbiter of constitutional questions because they have life tenure and blah, blah, blah. Jefferson goes on, the Constitution has erected no single tribunal. It has more wisely made all the departments co-equal and co-sovereign within themselves. Okay, that's an interesting statement. I mean, what does that even mean? Does that mean that there should not be judicial review? Is any branch going to declare their own laws unconstitutional? Jefferson probably has to be wrong here. What else is the court there to do if not to resolve conflicts like these? Last thoughts here. Was there another way that Marshall could have resolved this case? The other parting thought that you should think about, because it'll be useful to you on policy questions, is should we have judicial review? And if not, what's the alternative? I'm interested in your thoughts in the comments. Put them there.